functioning, up and running at the earliest opportunity. I can assure my noble friend that the Secretary of State and the entire ministerial team are focused on that outcome, and my right honourable friend has been having a number of discussions over the summer with the political parties towards resolving the issues which are preventing the reformation of the executive.
Consideration of Commons amendments on the Northern Ireland Troubles Legacy and Reconciliation Bill. The Lord Kane.
My Lords, I beg to move that the Commons amendments be now considered.
The question is that the Commons amendments be now considered. As many as are of that opinion will say content. The contrary not content. The contents have it. Motion A, the Lord Kane.
My Lords, I beg to move motion A, that this House do not insist on its Amendment 20 and do agree with the Commons in their Amendments 20A and 20B in lieu. I will also speak to motions B and C. My Lords, we have debated these issues at great length since this bill was introduced in your Lordship's House in July 2022. I will therefore speak briefly to the remaining issues today. I have always been the first to acknowledge the challenging nature of this legislation and how it requires some very difficult and finely balanced political and moral choices. The Government has, however, continued to listen and sought to strengthen the legislation. Since July last year, I alone have had over 80 meetings on legacy issues, mostly in Northern Ireland, but also in Ireland, the US and, of course, within your Lordship's House. My right honourable friend, the Secretary of State, has also had a large number of meetings on these issues. My Lords, I turn first to the amendments tabled under motion A1 regarding the conduct of reviews by the Commission. This amendment raised a number of important issues, and I am extremely grateful to the noble Lord Hayne of Neath, a distinguished former Secretary of State, for the manner in which he has engaged on these matters. This engagement has resulted in a number of key amendments to strengthen this aspect of the bill. This includes amendments expressly to confirm that the Commissioner for Investigations, when exercising operational control over the conduct of reviews and other functions, must comply with obligations imposed by the Human Rights Act 1998, and to make clear that the Independent Commissioner for Investigations will determine whether a criminal investigation should form part of any review. The noble Lord has therefore already significantly influenced this bill during its passage, and I genuinely thank him for that. Respectfully, however, I would suggest that the content of the noble Lord's amendment has been extensively addressed by the package of amendments tabled both at report stage and subsequently at Commons consideration by the Government. Indeed, my right honourable friend, the Secretary of State, tabled 2 amendments in lieu in the other place to address further the concerns raised by the noble Lord Hayne through this amendment. The first of these amendments, Amendment 20A, clarifies that the duty to look into all the circumstances of a death or harmful conduct when carrying out a review applies no less rigorously in a case where the Commissioner for Investigations has decided that a criminal investigation should not take place. Amendment 20B emphasised the importance of the involvement of victims' families in the review process, and it does so by placing the Commissioner under an express obligation to include in its final report answers to any questions posed by family members as part of a request for a review where it has been practicable to obtain the information as part of that review. I should remind the House that both of these amendments in lieu were accepted in the other place without the need for a vote. Turning to Amendment 20D in the name of the noble Lord Hayne, the Government is also enabled to accept the addition of a power that would allow the Secretary of State to prescribe standards under subsection 6A as an alternative to attempting to provide for those standards on the face of the bill. The Government considers it vital to safeguard the independence of the Commission, and this is something that we have worked very hard to do and to strengthen during the bill's passage in direct response to a number of points made in your Lordship's House and in our view, any such power as set out in the Noble Lord's amendment would run directly counter to this objective.
This intervention, and I thank him for his generous remarks earlier. The point that he hasn't so far said, and I hope he will acknowledge, is that the amendment says by affirmative resolution. In other words, it will require proper consideration by both houses. And my concern in the amendment, as I will explain, is that this bill can be further improved over time in the light of experience and the views of victims' groups.
Noble Lord, I think my point stands, though, that throughout the passage of the bill and in response to criticisms of the bill, which when it was brought from the other place, that the Secretary of State had too many powers vested in him. We have sought to divest powers and strengthen the independence of the Commission. This does seem to me to be running, whether it's affirmative or negative, whichever procedure is used in this House, it is running in the opposite direction. And I would also like to remind the House that the bill does already contain a provision in clause 35 requiring the Secretary of State to review the performance of the new Commission by the end of the third year of its operation. I turn next to the issue of conditional immunity, which I readily accept is the most difficult and challenging element of this legislation, but in the view of this government, essential if the new processes that the legislation establishes are going to have a chance of working. I'm very grateful, as always, to the Noble Lord, Lord Murphy of Torfaen, for his alternative proposal instead of insisting on the wholesale removal of conditional immunity, which, having been passed in your Lordship's House by 12 votes, was overturned in the elected House decisively by 92 votes, far larger than the government's actual majority in the other place. As I have said, conditional immunity is, in this government's view, an important mechanism to help the Independent Commission fulfil its functions. My Lords, very briefly, I remind the House that the aim of the bill is very simple and straightforward: to provide more information to more people in a shorter time frame than is possible under current mechanisms, to establish the facts of what has happened to those families that wish for that, and to help society both remember the past and to look forward to a more genuinely shared future. I understand that the aim of the Noble Lord, Lord Murphy of Torfaen's Amendment 44E, is to give family members a role in whether immunity should be granted or not. In the government's considered view, that would critically undermine the effectiveness of these provisions in their principal aim, the recovery of information for families. For example, the public consideration element in Condition D will lead to uncertainty as the circumstances under which immunity will be granted, undermining the clear and transparent approach that we have sought to develop. To ensure that the Commission can obtain as much information to families as it possibly can, we need to ensure that the right incentives are in place for individuals to come forward and provide that information. The possibility that eligible individuals who cooperate fully with the Commission could be prevented from obtaining immunity is highly likely to act as a significant disincentive for individuals to disclose information. As the House is well aware from our numerous debates over many months, the Commission will grant immunity from prosecution only if individuals provide an account that is true to the best of their knowledge and belief. We have developed a more robust test for immunity in which that account must be tested against any information that the Commission holds or can access. The Commission must, as a result of amendments in your Lordship's House, take reasonable steps to secure additional information needed to test the truthfulness of an account. If an individual does not provide a truthful account of their actions that could be passed to families, or does not participate in the immunity process at all, immunity will not be granted, and that individual will remain liable for prosecution should the evidence exist. And where prosecution takes place, should a conviction be secured, an individual will not be eligible for the early release scheme under the 1998 Northern Ireland Sentences Act, again as a result of amendments passed in this House. Similarly, while I acknowledge the sentiment behind introducing the so-called licence conditions under Amendment 44E, I would respectfully suggest that the Government has sought to address these issues through amendments that were agreed at report stage. These send a clear message that once immunity is granted, individuals who are convicted of offences that could impede reconciliation will lose that immunity. In our view, this strikes the right balance between providing sufficient certainty as to the effect of a grant of immunity and ensuring that there are appropriate consequences for those whose behaviour after being granted immunity is not compatible with the fundamental aims of this legislation. The alternative brought forward by the Noble Lord, Lord Murphy, would not support an effective information recovery process, and therefore I would ask that the Noble Lord do not insist on his motion B1. Finally, the legislation as originally introduced gave the Secretary of State a power to write in the date for the relevant day in respect of the cessation of inquests and criminal investigations. However, the clarity brought forward at report stage through amendments in relation to these matters removed the requirement for defining the relevant day. Amendment 119A is therefore entirely technical in nature and seeks to remove that power as it is no longer necessary. I wish to close by expressing my gratitude for the manner in which noble lords across the House have engaged, scrutinised and sought to improve this bill, and I pay particular tribute to the opposition for their patience and encouragement on the bill. I'd just also like to add, as I was unable to do so at third reading, my thanks to officials who behind the scenes have worked tirelessly and put in an incredible amount of work on this legislation. My thanks go to them, Parliamentary Council, for the standard and quality of amendments they've drafted, and all the officials in the NIO and Whitehall who have worked on this bill. My Lords, in conclusion, I ask noble Lords not to insist on motions A1 and B2 and instead to agree with the Commons in their amendments in lieu under motions A, B and C. My Lords, I beg to move.
The question is that motion A be agreed to. Motion A1, Lord Kane.
My Lords, I beg to move motion A1 as an amendment to motion A, leave out from 20 to end and insert do disagree with the Commons in their amendments 20A and 20B and do propose amendments 20C, 20D and 20E in lieu. My Lords, can I again thank the noble Lord Kane for his generosity, and yes, it is true that he, having been clearly uncomfortable with this bill from the outset, a bill imposed from elsewhere in the government machine, has sought to at least come some way towards the really deep concerns and criticisms of it that were expressed on a cross-party basis. So, yes, he has made some concessions, but frankly, they haven't got anything like far enough to satisfy victims groups especially. This bill remains toxic for almost all victims groups in Northern Ireland, and it has not been supported, even in its amended form, by any political party in Northern Ireland, so far as I'm aware. Therefore, my Lords, this amendment that I am moving ensures that there's an opportunity to improve over time, by affirmative resolution, not by executive fiat, what will soon be an act, and thereby create a measure of consent for it, where currently there is absolutely none in Northern Ireland, amended or not. For as the sorry bill slithers towards royal assent, one thing is clear. Despite the willingness of the noble Lord Kane, the Minister, to engage in listen, as he has done to me regularly, for which I thank him, he's gone out of his way to listen and discuss, and despite the amendments he's tabled marginally improving a truly terrible bill, the government has monumentally failed to persuade Northern Ireland's victims and survivors that what is being done in the name of reconciliation is even remotely in their best interests. Instead, the government turns its back on them, saying, "Take it or leave it, we are done with you." But even when the bill leaves here with all its worst excesses and goes to the other place, that will emphatically not be the end of the story. Emphatically not be the end of the story, my Lords. Hence the need for my amendment. There remain serious doubts as to the legal basis upon which the bill is founded. When Sir Declan Morgan, an outstanding jurist of unimpeachable integrity and the immediate past Lord Chief Justice for Northern Ireland, and who's been appointed Interim Chief Commissioner of the ICRIR, was asked if he believed that the legislation was European Court of Human Rights compliant, he said, and I quote, "I'm not going to express a view." But the Secretary of State at the time that the bill was published did express a view that it is, and I've no doubt that the noble Lord Kane, the Minister, will express that same view. What else could he do? And just last week, Sir Declan said that he welcomed victims challenging the legislation in the courts, that he welcomed them challenging the legislation in the courts. My Lords, what on earth are we doing to victims? Will they welcome being forced to go to court to fight for their basic right to be treated fairly and with respect and dignity and within the law? For that is what the government is doing to them. There's no doubt that the bill's immunity provisions will be challenged, and very possibly the review investigations mechanism as well. In my amendment in lieu, I set out a mechanism whereby the Commissioner can move towards a Canova-type operating model endorsed by this House, but rejected by the Commons, that is demonstrably European Court of Human Rights compliant, and evolve it in the light of experience, evolve the bill in the light of experience and the views of victims' groups, or indeed if the courts rule against what is currently proposed, as many think is likely. It's a very modest amendment, but if it is adopted, then change can evolve by affirmative resolution, not ministers just deciding, by affirmative resolution rather than ministerial fiat, or going through further lengthy years of consultation and fresh primary legislation on this perhaps most thorny and difficult of issues in Northern Ireland's great list of difficult issues. I tried to address it with the Eames-Bradley report. The noble Lord has grappled with this issue for years. We've all tried to address it as former Secretaries of State. It's very, very difficult. And if this bill doesn't have the support of those it's designed to address, then surely it should be allowed to evolve in the light of representations, and that was what my amendment provides for, rather than going through years of further grief and consultation and fresh primary legislation. So I do appeal to the noble Lord the Minister, even at this late stage, to accept my amendment, and by doing so achieve a measure of support for a bill that currently has none. I beg to move.
The original question was that motion A be agreed to, since when motion A1 has been moved as an amendment to motion A. Leave out from 20 to end and insert the words as printed on the marshalled list. The question, therefore, is that motion A1 be agreed to.
My Lords, I beg to move the amendments, complicated amendments, in my name on the order paper, and wish, like the Minister, to pay tribute to his civil servants who worked very hard on this bill during the course of a very long 13 months, and also to thank the Minister himself for the courtesy and the diligence with which he's taken this dreadful bill through this House. I don't for one second believe that the government was wrong in trying to address the issue. It has, of course, to be addressed. It's a difficult one. The governments and people of Northern Ireland have tried for a quarter of a century to try to deal with it, and generally speaking, have failed. And so there's no difficulty in accepting the fact that the government should try to deal with it. But I believe in this particular instance, particularly because of the most central and controversial part of the bill, which is the issue of immunity, it has not succeeded in acquiring the support that it would deserve under normal circumstances in Northern Ireland. When your Lordships agreed some months ago to the amendment that I tabled to delete entirely Clause 18 of the bill, which is the central clause dealing with immunity and therefore the central and most controversial issue of the bill itself, even though it was defeated in the House of Commons and has now come back, because the clause was defeated here, it meant that two important amendments which would have been debated on that occasion, one tabled by my noble friend Lord Hayne, and one tabled by the noble and reverend Lord Eames, weren't given the opportunity for your lordships to consider. My amendment is an amalgamation of both of them, dealing with licence conditions and with family consent. And I would again point out to the House that those amendments were originally moved by a former Secretary of State and by a former Church of Ireland Primate of all Ireland and Archbishop of Armagh. So they were serious amendments about serious issues. And I believe that the government has indeed tried to remedy some of the worst injustices of this bill, and I thank the government for it. But it hasn't got enough. It hasn't gone far enough. It hasn't addressed the real issues which have been expressed in the course of the last 13 months when this bill has gone through. My noble friend Lord Hayne has referred to the comments of the Commissioner Designate, Sir Declan Morgan, and I share his view that he is, of course, a very considerable and significant jurist, but did indeed say that the issue of compliance and compatibility with the ECHR would now be a matter for the courts in international law. And we heard only last week that the Irish government is actually contemplating taking serious legal advice about going to court. Now, that can't be right in a bill as significant as this. And Sir Declan also went on to say that this bill has virtually no support in Northern Ireland. That, I think, is one of the major understatements I've heard for a very long time. My lords, every church in Northern Ireland is opposed to this bill. And Northern Ireland is a very church-going place. And if all churches are against it, then that should be taken seriously into account. My lords, every single political party, every one of them, whether they be nationalists, Republican, Unionists, or none of those things, are opposed to it. Every victims group and the Victims Commissioner is opposed to the bill. The Equality and Human Rights Commissioner and Commission is opposed to it. All human rights bodies in Northern Ireland is opposed to it. The Irish government doesn't like it. The Council of Europe has disagreed with it. The United States government is dubious about it, and the United Nations is against it. With all that opposition, why on earth is the government insisting on proceeding with this? Now, my amendment wouldn't solve the whole difficulty about a bad bill, but it would mean that the involvement of victims' families and the ability to impose conditions on immunity, including the right to revoke it altogether, would improve it. But we've heard that the Minister isn't going to accept that. But the best solution, my lords, is for this bill to be put on hold, to be frozen, in fact, until such time that we have a properly governing executive and assembly back in Northern Ireland, and those are the people who should decide how these matters should be dealt with. And so once again, and finally, I suspect, I appeal to the government to do such a thing, because the Minister knows that imposition on the people of Northern Ireland never works, nor should it do.
Whilst I think that this House is faced with two rather undesirable options, I very much prefer the position advanced by the government to that advanced by the noble Lord Murphy. Lord Murphy's amendment would, if accepted, preclude immunities in the most part for being granted. The government's position does allow for the possibility of immunities, albeit one surrounded by provisos and caveats. I personally take what I know to be a minority view, that the proper way forward is for a statute of limitations to preclude all prosecutions for all offences alleged to have been committed prior to the Good Friday Agreement. And this would apply both to security personnel and to alleged terrorists. I don't think it is possible to make a distinction as between the two. And my reason is a very simple one. There is, I believe, a serious disparity between the position of former servicemen and the way they are being treated, that is to say, that they are at risk of prosecution, and, for example, the distinction, the positions, the respect which have been accorded to people who have been alleged to have committed former terrorist acts. And I have in mind, for example, Mr. McGuinness. I have the greatest respect for the courage of Mr. McGuinness in his decision to renounce terrorism and to participate in constitutional government. But you cannot overlook the past entirely. And it seems to me to be wholly wrong in principle and an abuse of legal process to expose former servicemen whose culpability is probably very much less to the risk of prosecution when at the same time you have given positions of honour and respect to people who have committed alleged crimes. And it's for that reason that I would favour very much a statute of limitations, and I'm prepared to call it an amnesty. That is what we recommended when I was in the Foreign Office to many countries which have been through periods of civil discord. And that is what I think is the proper way forward. But I know full well that that is not a majority view, either in this House or in the province, or indeed in Ireland itself. And that being so, I favour the position adopted by the government, rather than that advocated by the noble Lord, much as I respect him.
My Lords, I rise to speak the noble Lord, Lord Haynes' amendment to the noble Lord the Minister's motion on clause 13, and also the noble Lord, Lord Murphy's amendment to the noble Lord the Minister's motion on clause 18. My Lords, this bill removes from victims of the Troubles throughout the United Kingdom fundamental legal rights. The aim of the bill is clear. The Minister referred to the purpose of the bill in his introductory remarks, but actually the long title of the bill says that its purpose is to limit criminal investigations, civil legal proceedings and inquests, despite the fact that by May 2024 there will be some 15 outstanding legacy inquests to be heard. It's also to prevent police complaints investigations, and all that into matters arising between 1966 and 98. All these ancient and balanced legal procedures are being removed under the bill, and it has to be said that all the protections and the powers within the courts have in the conduct of criminal, civil and inquest proceedings. The noble Lord the Minister's amendments do not address the deficiencies identified in the bill by so many across the world, as noble Lord Lord Murphy referred to them, and the other places' responses to the amendments made in your Lordship's House don't address the deficiencies identified either. My Lords, it is important to remember that the Council of Europe, its Committee of Ministers, the Parliamentary Assembly of the Council of Europe, the UN High Commissioner for Human Rights, the UN Special Rapporteurs, national human rights organisations, our own parliamentary committees, civil society organisations, all political parties in the UK with the exception of the Conservative Party, political parties in Ireland, the US, victims groups, community groups, have all declared the bill to be unacceptable because of its manifest deficiencies and because of the breach of our international legal obligations. And I would remind noble Lords of the fact that under the bill, the ICRIR doesn't even have powers to demand information as of right, but must justify each request as reasonable. That doesn't happen, my Lords, in normal criminal investigations. Yet, untrammelled access to information is fundamental to the conduct of criminal investigations, and it has frequently only been the determination of judges, of coroners, of lawyers and of litigants which has resulted in the disclosure of relevant and important information which should have been disclosed as a matter of course. And even in that situation, the police and the MOD have frequently said they can't produce the material because they don't have the resources to do so. And my Lords, the answer to this situation cannot be to close down the justice system. Rather, as Patton recommended, policing must be delivered in the context of a coherent and cooperative justice system. We don't have that in Northern Ireland. For example, the Canova investigation submitted some 33 files from 2019 onwards. No decisions have been made by the Public Prosecution Service because the Public Prosecution Service doesn't have access to the lawyers it needs. And, my Lords, the Secretary of State and the Noble Lord the Minister keep reiterating that resources must be found within the Northern Ireland budget. Yet what happened in Northern Ireland over those years of the Troubles was not the responsibility of paramilitaries alone. Agents of the state also played their part. In my 2007 report on the case of the murder of Raymond McCord Jr. and associated matters, I said that it has emerged that all of the informants at the centre of this investigation were members of the UVF. There was no effective strategic management of them, and as a consequence of the practices of Special Branch, the position of the UVF, particularly in North Belfast and Newtownabbey, was consolidated and strengthened. Information was withheld, instructions were given that matters should not be recorded. The general absence of records has presented senior officers who clearly have significant responsibility for failings from being held to account. It is abundantly clear, I said, that this was not an oversight. It was a deliberate strategy, and it had the effect of avoiding proper accountability. My Lords, that was accepted by the Chief Constable of the time and the Secretary of State, and in many other cases there were similar findings. It is these situations for which the state had responsibility, which demonstrate what happened and which show the responsibility of the state for some of what happened. That is why the government has, I would argue, at the very least, a moral duty to support those engaged in the pursuit of justice and truth, and not to impede their search for justice and truth by the passing of this bill, for that is what this bill, in its final form, will do. Your Lordships have discussed at length the requirements of the Convention on Human Rights in the context of investigation. We have pondered the government's commitments under the Good Friday Agreement. My Lords, the Noble Lord the Minister's Motion A doesn't make the bill ECHR or Good Friday Agreement compliant. The Noble Lord Haynes amendments would at least impose an obligation for any regulations made by the Secretary of State in this context to be compliant with the European Convention and be subject, as he so articulately said, to the affirmative procedure. My Lords, the conditional immunity scheme, despite the government's amendments and the others which were tabled by Noble Lords in this House, remains in breach of the government's agreements under the Good Friday Agreement to provide people with access to the courts and remedies for breaches of the Convention. That fact is profoundly important. My Lords, the victims' groups, such as the Truth and Justice Movement, regard this bill as destroying their democratic and human rights to truth and justice. Nobody, not even the government, thinks that this bill will provide truth and justice, let alone reconciliation. The Secretary of State has repeatedly acknowledged the problems with the bill. He stated most recently, the government believes that the conditional immunity provisions will be key in helping to generate the greatest volume of information in the quickest possible time. My Lords, there is no evidence to demonstrate that immunity will have this effect, and it's well known that former paramilitaries involved in murder really have no incentive to tell all. All they have to do is sit out the 5 years within which cases may be brought for review. And even when information is provided, it is rarely the whole truth. On some occasions, information which has been provided has been demonstrated to be untrue. My Lords, the conditional immunity scheme which the Noble Lord the Minister is again promoting and which we are debating would result in impunity for serious human rights violations, the unilateral shutting down of avenues to justice for victims, and would give rise to questions about the ability of the Independent Commission for Information Recovery to deliver outcomes that would meet human rights standards. The Noble Lord Murphy seeks by his amendment to provide the victims of the Troubles, the close family members of those who died, with the right to be asked for their consent to a grant of immunity. It states that the Chief Commissioner must be satisfied that consent has been given and that no other close family member has raised an objection within 3 months of the initial consent being given. Alternatively, when no consent is given within 3 months, or an objection is raised by a close family member within 3 months, The Chief Commissioner can decide that it's in the public interest to proceed with granting immunity regardless of the views of the family. My Lord, this modest amendment by the noble Lord Murphy seeks to put victims at the centre of the process of granting immunity. It is qualified by an overriding right for the ICRIR Chief Commissioner to determine that even when victims don't want immunity granted to a perpetrator, the views of the victims can be overridden in the public interest. My Lords, one of the problems of the current system is that judicial review has repeatedly been necessary to challenge decisions made by public authorities involved in dealing with legacy. JRs cost a lot of money. They take a long time to be resolved in our under-resourced legal system, and they cause immense further distress to victims. My Lords, if approved, the Secretary of State's amendment will simply lead to more judicial reviews. Rather than solve the problem, it will add to it. My Lords, your Lordships were right to remove Clause 18 from the bill. The other place has, as it's entitled to do, overridden your Lordships. This amendment, in the name of the noble Lord Murphy, will at least qualify the operation of Clause 18 by inserting some recognition of the fact that any process which ignores the views of victims simply has the capacity to cause them even more suffering, rather than to promote reconciliation. My Lords, as the noble Lord Murphy and the noble Lord Haynes said, the bill is fatally flawed. It deprives people across the United Kingdom who suffered so grievously during the Troubles of their fundamental rights under the Good Friday Agreement and the European Convention, the Human Rights Act. If and when it is passed, it will lead to lengthy and complex litigation, something welcomed by Lord Chief Justice Declan Morgan. My Lords, this is not the way to promote reconciliation in a divided society. My Lords, in the event of a division, I will support both the noble Lord Hayne and the noble Lord Murphy.
My Lords, I once more find myself speaking as earnestly as I can in support of the sentiments of two former Secretaries of State of Northern Ireland. Two men who undertook those tasks at times of division, at times of suffering, and at times of what I can only term injustice to so many people in Northern Ireland. And the fact that two men who had that experience have voiced sentiments in your Lordship's house this afternoon and have spoken in terms of their experience, I cannot understand why His Majesty's government do not understand that there are those outside this chamber and outside this Mother of Parliaments who cannot understand why their voices are being ignored. Yes, there have been attempts to bring the concept of victimhood into the legislation that's proposed. Yes, the government can claim that they've made efforts, but in God's name, I ask your Lordships to consider what is the overall impetus of what changes have been made to try and recognise the needs of victims, of their families, and of those who in years to come, when they read what has been said, what has been attempted, what has failed to be produced, will find it's incredulous to understand that the Mother of Parliaments has ignored their crying. Lord Murphy was kind enough to refer to the efforts I made at a report, and before that, to try and bring the sentiments he's expressed in his amendment before the House. I don't want to go over that again, except to say at the back of my mind, as I listen to this, what is final debate of these issues, I cannot come to any peace of mind that future generations will not condemn us for not recognizing the human cost. Yes, the human and emotional and spiritual cost that we are putting before the people of Northern Ireland. I cannot find words strong enough to express my personal hurt and my personal ongoing dismay that the opportunity is being given to His Majesty's government not to wreck this bill, but to make it better, to make it stronger, and above all, to make it more amenable to those who are the subject, or should be the subject, of our concern, namely the victims. And so there will be much discussion about the technicalities, about the and about what we're proposing to do. But I make this appeal to the House. Please hear the voices of those who have condemned what is happening and have made the simple human plea. Please remember we have carried the hurt, the pain, and the loss over the troubles in Northern Ireland, and you have the opportunity now to do something about it. Please, my lords, don't miss the opportunity.
Pleasure to follow the noble Lord Eames on this very difficult and vexatious issue that impacts not only on most families in Northern Ireland and Ireland, but also in the UK, the wider UK as well. Because many people have been impacted by the untimely and summary death of a family member as a result of the Troubles. So therefore, very clearly, victims should be central to this bill. And as this House has said, and has been articulated by the noble Lord Eames and by Baroness O'Loan, victims should be central to it. But I'm sorry to say that victims are not central to this bill. It's an issue probably of experience on the part of the government to deal with this particular issue, and that is totally unacceptable. My Lords, I will be supporting both amendments in the names of my honourable friends, the noble Lord Hayne and the noble Lord Murphy, if they choose to put them to a division. And it is interesting to note, my Lords, that we are joined today in the public gallery by some of the representatives of victims from Northern Ireland. Raymond McCord, whom the noble lady Baroness O'Loan referred to earlier, and his colleagues. And they have direct experience. And they have told the government, they have told the Irish government, they have told the European Union, and they have told political parties in Northern Ireland and this House and the other place that this bill will not meet the needs of victims, and victims will be undermined. But in all of this, on Monday of last week, Sir Declan Morgan gave an interview to the Irish News dated the 28th of August, and that has already been referred to by the noble Lord Hayne and by the noble Lord Murphy. And when I bought my Irish News last Monday morning, I was immediately struck by the heading. The Legacy Board Body Chair welcomes any legal challenges. I would like to tell him there will be legal challenges, because it will not only come from the victims' groups, it will probably come from the Irish government and from other bodies within the European Union, because the European Commissioner has already highlighted the issues around immunity, because there is no doubt that this existing bill will impede justice and truth. It will relegate victims to not the second division, but the 8th or 9th Division. And I would implore the Government at this late hour to support the amendments in the names of my noble colleagues. And if that is not possible, please stop this bill and please stop further hurt in an already divided society that has seen so much over the last number of weeks in relation to policing and in relation to victims and in relation to this particular bill and legacy, because those were the two thorny issues out of the Good Friday Agreement that required resolution. We thought the policing one was resolved. Now it appears that it requires to be a greater, shall we say, investment in the structures to ensure that there's proper retention and proper recruitment and a return to 50-50 recruitment, and that police officers and civilian staff are properly protected. But in relation to victims, they also need to be protected. And I would ask the noble Lord the Minister, in his wind-up, will he demonstrate to this House how this bill will be human rights compliant? Because I do note what Sir Declan Morgan has said. He is committed to ensuring that the Commission is human rights compliant. And from his interview, I would deduce that Sir Declan is probably querying now whether the bill, when enacted and if enacted, will be human rights compliant, and will it comply with ECHR. I know, my lords, where I stand. I stand with the victims of the Troubles on all sides, whether their loved ones were executed by paramilitaries or by state forces. Victims come first in all of this.
We return to this issue of legacy, possibly for the last time, almost certainly in this House as far as this bill is concerned, but certainly not for the last time in this or the other place, and possibly sooner than expected. I have no difficulty in supporting the amendments brought forward by the noble Lord Murphy of Torfaen. They represent an improvement on what is currently before the House. For those we all know and acknowledge, and it's been said right across all sides of the House, that all the amendments, including the ones brought forward by the Government during the passage of the bill, do not and cannot rectify the fundamental flaw which is at the heart of this bill, and that is providing immunity from prosecution to terrorists. As the noble Lord Eames said so passionately and eloquently, what will future generations think of this Mother of Parliaments that was prepared to do such a thing on innocent families? Nevertheless, my Lord, some important work has been done to try to mitigate some of the worst aspects of this wretched piece of legislation. Although I do regret that despite our best efforts, the glorification of terrorism has still not been adequately addressed in the Government's amendments. And again, week after week, in Northern Ireland and in the Irish Republic, we see the glorification, led by Sinn Féin and the person who would want to be the First Minister of Northern Ireland, supporting and glorifying in the bloodshed and terrorism that the IRA, and they weren't the only ones to engage in terrorism, but they're the ones that are most to the fore in glorifying it, much to the trauma and pain and hurt of their victims. The Government brought forward a number of amendments, some of which had originally been tabled in the other place by my party colleagues, especially Gavin Robinson. I think of the appeal of the Northern Ireland Sentences Act 1998, which the noble Lord the Minister referred to, as well as the increase in fines. It's also beneficial to the bill that there's now the ability to revoke immunity should it be obtained through deception or lies. Again, that was tabled in the other place by my party colleagues. And the Government committed in the other place to delivering that change in this House, and it's good that that was done. I'm glad that in terms of these amendments, both in the other place and here, there's been a lot of heavy lifting done by colleagues over many, many hours in opposition parties, as well as by colleagues on our own benches, in an attempt to improve what is fundamentally flawed during long, what appeared sometimes to be interminable debates, often with very few outside those who were really interested present. It's been argued by some that because of previous betrayals of victims and the previous setting aside over many years of the principle of justice in various ways, we should now somehow not be too hard on this bill. People have referred to the on-the-runs legislation, to letters of comfort that were handed out to terrorists, to Republicans via Sinn Féin, and indeed to many other things that happened to the hurt of victims under both Labour and Conservative governments. But, my lords, that's not something that victims say to us today. And I'm glad that our party in Parliament and outside Parliament, and many others, stood with innocent victims and opposed those previous obnoxious steps which were taken to appease terrorists and their supporters at that time. We opposed them then, just as we oppose this legislation, not out of any idea of populism, but as a matter of principle. We have been consistent in that. And indeed, we opposed one of the greatest betrayals of victims, when those guilty of some of the most heinous crimes imaginable, including mass murder, were given early release in 1998. Something to this day, when you speak to victims, traumatised many of them, and which was cheered on by those who should have known better, and indeed did know better at the time. And it's right, I think, as we finish these debates in this House, to call out some of those people who purport to stand on the side of victims. We hear about all the political parties are opposed to this legislation, and that's right, but Sinn Féin purport to talk about victims and victims' rights and justice, and they are the greatest perpetrators of murder, and who still to this day glorify it and defend it. They can't speak for victims, and their cynicism and opportunism should be called out, nor can the Irish government for that matter, who for many decades harboured terrorist fugitives from Northern Ireland and refused to extradite them to Northern Ireland for justice. So whatever about the issues in this bill, and we're opposed to it, it ill becomes the Irish government in particular to complain, even to this day, refusing to cooperate properly in regard to allegations of collusion between the Garda Síochána and IRA terrorists in relation to a number of incidents in the Irish Republic, and who still refuse to instigate a public inquiry in relation to the Omagh atrocity. So, my lords, all along we have believed that the victims, as other noble lords and baronesses have said, the victims should be listened to. It's their crying that should be taken account of. That if the evidence justifies it, then terrorists should not be able to hide or escape justice by having the ability to invoke some kind of immunity or amnesty, condition or otherwise. And in closing, I want to pay tribute to those innocent victims. I think of the delegation which came to Westminster in late January of this year. Amongst them was Pam Morrison from County Fermanagh, who will be known to many from Northern Ireland, whose three brothers, the Graham brothers, were all brutally murdered by the IRA, one by one, between 1981 and 1985. And she also lost her sister, serving with the UDR. 4 brothers and sisters. Pam pleaded with the government to listen. They have refused. But I have no doubt that we will hear her voice again, and we will all return to this subject soon.
My Lords, amendments which I think are really an attempt to
respond in a way to the way the Minister has engaged with this bill. And before I do, can I say that I'm speaking on behalf of my noble colleague Baroness Sutty, who has been very engaged in the bill and is unable to be here today. And I know that she was very appreciative of the engagement from the Minister, and indeed I've sat in one or two of those meetings myself, as well as these debates. And many of these arguments have been rehearsed many times, and we don't need to say them over and over again. And I only want to say two or three very brief things. I think the heart of this bill is that there's an attempt to provide immunity, yet it was driven by a minority within the Conservative Party who really only wanted to give immunity to one side. And it's actually not possible to do that without giving immunity to the other side. And that is why nobody can support this bill, because nobody can feel satisfied that they can secure justice in that environment. The question which has been raised too about compatibility with the European Convention of Human Rights and indeed the possibility of tests in the court. I had the honour to serve as a member of the Parliamentary Assembly of the Council of Europe and was a member of the Legal Affairs and Human Rights Committee. And I think most of the democratic members, and all the members of the Council of Europe were democratic, which is why Russia is no longer there, recognised that the point about the convention and indeed the existence of the court was to try and avoid matters going to court, but recognising the court was there when failures had taken place. So I find it extraordinary, as does Baroness Ritchie, that the government and the government's representative in this context should be actually saying, well, let's test it in the courts. Because the question I have to the Minister then is if a case is taken to the ECHR and determines that this bill is in contravention of the convention, and of course all that will take time, and no doubt the measures that this bill provides will have been implemented and followed through, what will the impact of this be? Will that mean that all of the decisions that have been taken under this legislation will be invalidated? But in the meantime, as Baroness Alone has said, many inquests which are currently nearing progression, at least to a point where they could continue, will have been abandoned by this. And I would suggest this government or its successor would find itself in an extraordinarily difficult situation, which also would be very difficult to remedy because so much damage would have been done. So I think that all of us in this House, apart from on the Conservative benches, are quite clear that this bill shouldn't be going ahead. But I think the Minister should acknowledge, as we've acknowledged in turn to him, that there has been genuine engagement to try and move the bill, even though we all agree it shouldn't be there at all, to the least, if you like, damaging place. And these amendments are designed to be helpful in that spirit. And I think, frankly, it would do the government a lot of good if they were prepared to accept them, because it would show that the goodwill was both directions. And I would certainly make it clear from these benches that if a division is called on either of these amendments, these benches will support them. I mean, Lord Eames, in fact, if give me a very short intervention from him, but one that was so passionate in terms of his dismay and hurt, as he put it. And I think many of us know how uncomfortable the Minister must be when almost anybody and everybody who's been involved in this in Northern Ireland says this is wrong, this shouldn't be happening. And I don't think this will stand the test of time as anything other than a very dishonourable and disreputable course of action by a British government. So I think at this stage I would perhaps just pick up one point that Lord Dodds said, or the context of his speech, because the bill is supposed to provide reconciliation. I think it's been said on many occasions it doesn't do that. But the speech of Lord Dodds actually demonstrated not only does it not provide reconciliation, it actually aggravates grievance, which is the exact opposite of what was the intention. And that is extremely disappointing. So I would just like to say I think Lord Hayne and Lord Murphy's amendments are constructive and helpful. The particular point about the Canova process has been well respected by everybody, and given the resources could have actually led to progress. And Lord Hayne's amendment is commendable for that reason, and indeed the rights of victims to be properly consulted which Lord Murphy is seeking to do, is absolutely essential. And as Baroness Ritchie has said, the victims are at the heart of the problem, and the victims are the people who are being most ignored by this piece of legislation. In that context, I hope the House will be prepared to sort these amendments, which means, of course, we will be back here debating them again in the not-too-distant future.
I don't support the amendment from the noble Lord Hayne, and I think that, in fact, he seems to be attempting to turn the ICIR and its reviews into the sum of all the existing legacy re-investigations that already happened, by the PSNI, the Police Ombudsman, and by Canova under John Butcher. And I think the amendment that he's put, it's complicated. It is a complicated amendment, and it would effectively mean that the new arrangements would be actually no different from what went before, and that the time required and the funding involved would be limitless, as I've said in the past. Given we've sent some £2 billion already to date on Troubles re-investigations for little resulting value, if we're honest, that is not, to me, an attractive prospect. And the amendment also attempts to bind the ICRIR to the international standards required by the European Court of Human Rights at Strasbourg. Now, the government, I thought, has already dealt with that aspect in a very late amendment by invoking the Human Rights Act. That Act has domestic UK effect, which is exactly appropriate for the ICRIR, rather than having to respond to the political machinations, I would say, of the Court's enforcing body, the Committee of Ministers of the Council of Europe. Now, in the earlier stages of the bill, the noble Lord Hayne and others presented the Canova process as a model for the ICRIR. That option seems to have disappeared from today's amendment, and I'm not quite sure why the name has been removed. But it is important, I think, to look a little bit at the background and the history. And the noble Lord himself knows that he played a very important role in an earlier stage of legacy policy, as Secretary of State for Northern Ireland, between 2005 and 2007. And in July 2005, 7 years after the Belfast Agreement, the IRA, they, in their words, dumped arms. And a few months later, the government responded with the Northern Ireland Offences Bill. This proposed an alternative justice system outside the existing institutions in order to deal with the legacy of Northern Ireland's past. Now, government ministers have not mentioned this precedent for their current bill, but they could well have cited this attempt to further the process conducted by the then Prime Minister Tony Blair and Jonathan Powell on behalf of the government, and by Gerry Adams and Martin McGuinness on behalf of Sinn Féin IRA. And the political situation in 2005-2006 was not unlike that prevailing during the course of this current bill, because then the Secretary of State, the noble Lord Hayne, was opposed by all other local parties except for Sinn Féin. But Clause 1 of the 2005 bill referred to offences, quotes, in connection with terrorism and the affairs of Northern Ireland, brackets, whether committed for terrorist purposes or not. And this meant the amnesty provisions, and it was an amnesty, and I think that noble Lord Hilsham has been very honest in his speech about the word amnesty. This meant the amnesty provisions could extend to the security forces. Immediately, in the other place, in December 2005, Mark Durkan, the leader of the SDLP, asserted that the Bloody Sunday soldiers, still being inquired into by Lord Savile, could benefit from the bill. And Sinn Féin immediately drew its support from the bill, and in January 2006, the noble Lord then dropped the bill. But of course, it's important to remember that the Republicans and the IRA, Sinn Féin, did not lose out, because Gerry Adams, Martin McGuinness had been working on Leon Run's scheme, which would soon move into its Operation Rapid phase, with comfort letters being issued, as the noble Lord Dodds has said, being issued to several hundred IRA men. So 20 years, time on, this bill, many imperfections, sets out what the government believes is a new model for addressing the legacy of the Troubles, something that wasn't considered, and everyone's honest now, wasn't considered back in 1998, and which the local political parties have not been able to agree on since.
And I do, therefore, oppose this amendment, because I just think it's bringing us right back to where we started and isn't moving forward in any way, no matter what we think of the actual bill. I do want to mention the amendment in the name of the noble Lord Murphy of Turpin, because I'm pleased that I was signature to the noble prelate Lord Eames in his amendment, which we put and which did not get put to the vote. But this amendment, picked up by Labour's front bench, I think is beginning again to start to put the victim at the centre of the whole issue. And I felt that this was some way that in the end, if the person who is the victim has gone through the whole process of listening to someone who's come forward and said and given what they say is the truth, and everyone has listened and there's been a great deal of time, and in the end, the victim, the person who's really suffered, actually is prepared to accept that that person can have immunity, then I think that we can live with that. And I am disappointed that the government hasn't moved a little bit on that, because I think that there was some very sensible suggestions made on that at committee stage, particularly by the noble Lord Prelate. So I would hope today that perhaps they will come back and look at that. Overall, this legacy bill is, I hate to use that sort of expression, but it is a dog's breakfast. It's been sort of cobbled together in a way to try to please everyone and is ending up pleasing absolutely nobody. But the government is determined to put it through, which is why I have supported in the past certain amendments that would make it slightly better. And I think that that's all that we can do at this stage, but I certainly do not think that the noble Lord Haynes amendment is actually moving us forward in any way.
My Lords, I rise to deal particularly with the amendment of Lord Murphy and support, in as far as it goes, I think the good intentions of his amendment. I say as far as it goes because I think Lord Murphy himself would be the first to admit the limitations that can be brought forward at this stage of any amendment. There have been, I think, throughout this process, as Lord Dodds highlighted, from across this chamber, from all sides of this chamber, attempts to mitigate and ameliorate this bill. And I'm glad at least that some of those have been successful. And I think we should acknowledge that where there have been improvements made. It is undoubtedly the case that despite all of that, we are left with a bill which is unsalvageable, which is insupportable, and which perverts the course of justice to the detriment of victims. Nevertheless, as a House, I think we are left with no alternative, but where possible, to seize any opportunity to make any improvement, however small, that we can. And I support in particular the amendment of Lord Murphy because it seeks to put much closer to the heart of this bill the rights of victims and to put victims at the heart of it, irrespective of what community those victims come from, irrespective of whether they're from Northern Ireland or external to Northern Ireland, irrespective of what organisation has been responsible for making them victims. And it is right that as we deal with this issue, the ultimate focus should be on victims. I think when dealing with Northern Ireland, there are two glib but dangerous lies that are often told. First of all, that collectively there is guilt for what has happened throughout Northern Ireland, that we are in some shape or form all perpetrators. That is fundamentally wrong. The vast majority of people in Northern Ireland, from whatever community, never were involved with violence, never supported violence, got on with their day-to-day lives. And if there was acceptance, if there's acceptance of the idea that in some way there is a collective guilt, it gives credence to the notion that there was no alternative to violence. The vast, vast majority of people in Northern Ireland pursued that alternative, the democratic alternative. And the violence that was there was imposed by tiny minorities on both sides, and victims suffered as a result of it. It is also the second lie which is often told in Northern Ireland is that somehow collectively in our society we are all victims. Now there are many, indeed some in this House, who have suffered at first hand that victimhood, and there are far too many victims in Northern Ireland. But we are not all victims. I can say for my own part, I was fortunate enough to grow up in as relative normality as I can. I was not a victim. I cannot claim and do not claim victimhood, which is one of the reasons why I am particularly disturbed with this legislation, because it seeks to impose on others a system which denies them their opportunities. And I think the principal reason why I was not a victim in Northern Ireland, was because of the brave work of the men and women of our security forces, keeping us safe. And today particularly I want to highlight, because sometimes they're forgotten, the brave women of the security forces. In particular, this month represents the 50th anniversary of the formation of the Greenfinches, the UDR Greenfinches, the first enlistment. And they were indeed, I think, the first units within the British Army to serve alongside men in the front line. And 4 of the Greenfinches, Eva Martin, Jean Liggett, Anne Hurst and Heather Carrigan, paid the ultimate sacrifice for protecting ordinary citizens like myself against terrorism. And that is a very good reason why we cannot throw justice out the window. The reality is that if we accept this bill, and I appreciate from the point of view of this House there may be a limited amount that we can do, we accept the notion of a codification of the perversion of justice. To say that the victims, it takes away their right to have any prospect of justice. Now, there will be those who will say that given the passage of time, it is unlikely that there will be many convictions in Northern Ireland. There are practical barriers to getting a conviction. But I think that is fundamentally different between saying that and saying we are taking away your right or your opportunity to ever have justice. That is something which I don't believe that we are entitled to do. And indeed, we also say to those victims, from whatever source they come, your relative or you yourself are a lesser person than others, because we apply a different standard of justice than we apply in any other crime. And we must acknowledge that what happened throughout the Troubles was a crime. And worse than that, because not only are we throwing away the concept of justice and besmirching victims, but there is not even any countervailing benefit on the other side. The Minister, in his opening remarks, in opposing the amendment of Lord Murphy, said, well, of course, if this was to be accepted, this would effectively kill off the benefits of the system. We wouldn't have this information flowing. I would say, and it is deep regret, and it's something which I think that they can still rectify. If we look, for instance, to the Irish government at the moment, which is refusing to have an inquiry into Omagh, which, despite countless attempts from the victims' families, still has not provided all the information, for example, in the King's Mills massacre, which it holds. If the Irish government is not providing that flow of information, what chance is there of the paramilitary organisations opening up their books to say, here is what happened in the past? We are perverting the course of justice to sell fool's gold to people. Because if we are raising any level of expectations amongst families that they will get the answers to why their relatives were killed by terrorist organisations, the details of that, and if we seriously believe that, we are living in a fool's paradise. Because the reality is we will have traded in justice for no material benefit whatsoever. That is why this bill is fundamentally flawed, but why at least there is at least a step of mitigation in Lord Murphy's amendment.
I will rise very briefly on what I think is a very sad day. There is no minister in His Majesty's government who has a better command and understanding of his brief than my noble friend Lord Kane. He is rightly respected and admired in Northern Ireland and I think in all parts of your Lordship's House. He was clearly extremely unhappy about the bill in its original form. He has clearly tried very hard indeed to improve the bill. And to some small degree, it has been improved. But, my Lords, the speech that really should dominate this debate when it comes to be talked about in the future is the extremely powerful, moving speech of the Right Reverend and Noble Lord Eames. In my time as the chairman of the Northern Affairs Committee in another place, I got to know and love Northern Ireland, and I also came to respect a number of people, including Baroness O'Lone, but none more than Lord Eames, who was rightly held in fond affection throughout Northern Ireland, and who was looked up to, and who did so much, particularly with the commission that he and Dennis Bradley chaired. And what he said today was a very eloquent endorsement of the point made from the opposition front bench by a much respected former Secretary of State, Lord Murphy. And he effectively said this bill is really unimprovable. I missed some of the debates on this bill for domestic reasons, which many members of your Lordship's House are aware of. But I did speak at the very beginning on a number of occasions, and although it has been before your Lordship's House for over a year, it is still, frankly, an unacceptable bill because it does not command any support outside the government, and quite a number of us on the Conservative benches in both houses are very unhappy about it. There was a degree of impeccable logic in the speech of my noble friend Viscount Hambleton. There is a case for a statute of limitations. It's a clear, unambiguous answer, but it is equally clear, and Viscount Hambleton recognised this in his speech, that that would not command support either at the moment. But I do think it is incumbent upon the government, in view of the widespread concern, anxiety, and deep unhappiness, for them to pause this bill. We've got a new session of Parliament opening on the 7th of November, just a little over 2 months ahead. We have a fairly frenetic week this week and next week and a few days after. Then we break for the so-called conference recesses. We come back for about 10 days. There will be no further opportunity for detailed examination of this bill. And we can't play indefinite ping-pong. And I am one of those who's frequently on record as saying that, of course, the will of the other place, as the elected house, must prevail in the end. But, my lords, I think it would be doing a service to the people of Northern Ireland in particular to pause on this. But one service deserves another. And I revert to a point that I made during questions earlier this afternoon. It is incumbent upon political leaders in Northern Ireland to come together, to have an assembly and an executive, because the ultimate verdict on this bill should be given in Northern Ireland itself, after a close re-examination of all the alternatives including a statute of limitations. But, my Lords, this is not a bill that should go onto the statute books in the fag end of this session. And with every possible tribute to Lord Kane, and I genuinely mean what I said, I would beg him to have urgent conversations with the Secretary of State and to press the pause button.
Yeah.
Well, my Lords, I'm, as ever, extremely grateful to all noble Lords who've participated in the debate on these amendments. I will attempt to be very, very brief. I hadn't planned to make a long wind-up speech at all. I'll reply just to one or 2 points, if I may. Of course, the noble Lord Murphy of Torfaen, in his remarks, referred to the long history of attempts to deal with legacy issues. It was, of course, in 1998 put in the too difficult drawer. There have been subsequent attempts, none of which have come to a successful resolution. I refer to the valiant efforts of the noble and Right Reverend Lord Eames, his work with Dennis Bradley. I myself, as noble Lords know, was involved in the 2014 Stormont House Agreement, which, despite all of our best efforts, never managed to make it onto the statute book, and the level of consensus that we thought we'd achieved at the time very, very quickly evaporated. So there have been many attempts and many failures around legacy over the years. This legislation, as I made clear in my opening remarks, sets out a different approach. The overall objective is very straightforward. It is to try and get for victims and survivors of the Troubles more information about what happened to loved ones in a far shorter time period than is possible under existing mechanisms, in a context in which, unfortunately for many, the prospect of prosecutions and convictions is going to be vanishingly rare. I do, as I acknowledged as far back as the second reading of the legislation, totally understand and acknowledge the feelings of many victims and survivors. I've met so many over the years, and especially over the course of the past year, and for many the emotion and the grief and the anguish is as raw today as it was whenever the particular incident that caused them their loved ones to be lost actually occurred. I referred in my second reading speech last November to my friend Ian Gow, and only last week I dug out the letter that Ian sent to me on the 4th of June 1990, looking forward to lunch in the Strangers' Dining Room on the 11th of June, just a matter of weeks before he was so brutally murdered by the Provisional IRA. So I am acutely aware of the victims of terrorism. But I do say to noble Lords that if we are to pause this bill or to refer it to the Assembly, all we really are doing is setting ourselves up for a further significant delay in providing answers to victims and survivors of the Troubles. The noble Lord Murphy and my noble friend, and I'm Lord Cormac, and I'm very grateful, touched over his very generous words towards me. Talked about referring this back to the Assembly. I think I've said in the past, that it was always the assumption, going back to the Hasse-Sullivan talks in 2013, that these matters would be dealt with in the Assembly after the Stormont House Agreement, which largely covered devolved issues. Martin McGuinness and Peter Robinson, then Deputy First Minister and First Minister respectively, came to the then Secretary of State and said, Secretary of State, these issues are all far too difficult for us to deal with in the Assembly. Please could you take all the legislation through Westminster? And that's when we ended up trying to convert the Stormont House Agreement unsuccessful into legislation through this House. So I don't necessarily agree with the noble Lord that is the answer just to refer back to the Assembly. I have, I think, I dealt with the government's objections to the two amendments in my opening remarks, and I don't intend to add to them. The subsequent debate has taken on, to some extent, the nature of another second reading debate in which a number of issues have been raised, which have been debated extensively throughout the past year. So once again, with the greatest respect to the House, I don't intend to go over all of those points again. We have debated them exhaustively. I'd just like to comment on one point that the noble Lord Bruce raised, in which he referred to what might happen in the event of a case in Europe. All I can say on that is what I've said many times at this dispatch box, that the government is confident that the legislation is compatible with our international obligations, not least as a result of the amendments that we brought forward at report stage. I know that others disagree. The noble Baroness Lady Alone has made her views very clear on that. We respectfully disagree on this issue. One correction that I would like to make, noble Lord Bruce did refer to Sir Declan Morgan, the Chief Commissioner Designate, as the government's representative. I think that is not quite the accurate description. And of course, as I stressed in my opening comments, one of the things we've sought to do throughout the passage through the Lordship's House is to strengthen and bolster the independence of the Commission. And Sir Declan, I think in the interviews to which the noble Baroness referred during her comments, Lady Richard Downpatrick referred to, he's already shown that he'll be a fiercely independent chair of the Commission. With reluctance, I'm afraid. But, yeah.
The Minister for taking my intervention. In that same article, there was a subheading in the Irish News which indicated that the staff to assist Sir Declan would come from the Northern Ireland office. Can you confirm that that is correct? And how does that address the issue of independence of the Commission?
There are officials from the Northern Ireland office who are assisting with the establishment of the body. But the staffing of the body will be entirely for the Commission itself. It won't be. It's not a matter for the Northern Ireland office. We are at the moment, obviously, the legislation is not yet passed, so the body doesn't formally come into being. The Commission doesn't formally come into being until next year. So all that is happening is that officials from my department are helping with the establishment during that transition phase. My Lords, as I say, it has taken on something of a second reading debate, and we've heard many of the points that have been rehearsed extensively. Therefore, I think I would conclude by asking noble Lords not to insist on motions A1 and B2, and instead to agree with the Commons in their amendments in lieu under motions A, B and C, and pass this bill, which really is the clear will of the elected House of Commons. I beg to move.
King, especially the noble Baroness Alone and the noble Lord Eames and my noble friend Baroness Ritchie for their full support for my amendment. In the circumstances, I beg leave to, and reluctantly beg leave to withdraw motion A1.
Your Lordship's pleasure that motion A1 be withdrawn. The motion is by leave withdrawn. The question is that motion A be agreed to. As many as of that opinion will say content. The contrary not content, the contents have it. Motion B, Lord Kane. Move formally. Move formally. The question is that motion B be agreed to. Motion B1, Lord Murphy of Tolvain.
I beg to move motion B1.
The question was that motion B be agreed to. Since when motion B1 has been moved as an amendment to motion B. At the end, to insert the words as printed on the Marshal's list. The question, therefore, is that motion B1 be agreed to. As many as of that opinion will say content. To the contrary, not content.
Not content.
The question will be decided by a division. I will inform the House when voting is open. My Lords, voting is open. Clear the bar. Agreed to. As many as of that opinion will say content, and to the contrary, not content.
Not content.
The contents will go to the right by the throne, the not contents to the left by the bar. My Lords, there have voted contents 201, not contents 190, so the contents have it. Motion C, Lord King. The question is that motion C be agreed to. As many as of that opinion will say content.
Content.
The contrary, not content. The contents have it. Before we move on to the statement, my Lords, shall we give the House a few minutes to rearrange itself?